trouble in your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything look smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome. Welcome, everybody, to the show. I am your host, Daniel. Today is Judge DiSanto. So let's get started with this. Let me share my screen. Boy, that's awful. And I'm here.
You are interrupting me once again.
Your Honor, she just gave me the finger. I'm looking at the screen.
Hold on, right now. Don't interrupt my record. Do not interrupt the record right now. Both of you, please stop.
She said that she's seen your picture as part of a swingers club.
I
While we
never
were
said
standing
that. Listen, this might be laughable, but I will admit what I said. I had no.
William Branson versus Heather Collins, 240-2269.
Ready, Your Honor? Good afternoon, Your Honor. I'll never Mr. Branson, who sits to my right.
All right.
Good afternoon.
Good afternoon. And your name, sir, please?
William Branson.
All right, thank you. And counsel?
Good afternoon, Your Honor. My name is Micah Dalbala, appearing on behalf of the defendant. She did request 8:30 in the morning at the last hearing because she works at 11:30. I didn't get notice of adjournment till Friday. I sent a subpoena to a witness on Thursday that I filed with the court. I've been trying to facilitate adjournment, but I have to officially ask the court for that.
Okay, so the court will note that I originally, we were trying to do a date, not today, and then counsel was going to be unavailable. And then I picked today's date, and it was my mistake of picking 8:30 because I had already committed to serve as a panelist on a career conference day at Wayne State University. So I was there this morning, And it was my fault that I set that time. So once it was determined that there was a conflict, then communication was sent to your client. It was sent to you once we received your appearance. So that would be why you received that information on Friday, because that's when we received your appearance. And so.
Well, the holidays have come.
There was plenty of notice provided to your client where she could have potentially just asked about going into work late, having somebody cover for her for an hour or two, I'm not sure. But before we get to the request for adjournment, did everything occur that was supposed to have occurred regarding the
You ordered it.
let's see here. Number one, I ordered the parties to brief the issue of no certificate of occupancy and collection of rent. Counsel, did you submit yours?
I did, Your Honor. I believe both sides have submitted memos, Your Honor.
Somehow it's not showing in here.
I can approach with a copy for the court,
Okay, just one moment. And
or
then,
we can email it to you now, Your Honor, if you want. Whatever is more convenient.
well, then I also indicated that
An inspection?
there was, yes, counsel, please let me make the record, that the parties were going to meet where Mr. Branson, they would have an independent, they could each have an independent person, so Ms. Branson was not to be present. And there was supposed to be an independent person there with Ms. Collins to go over what the issues were regarding the repairs that need to be made. There was permission to take some photos as well, but they were not to video or photograph each other. So, did that occur? Because I believe that was set for Saturday, the next day, Saturday.
Friday at 5 p.m. There's obviously.
Friday at 5 p.m.
Yes.
That's right, okay.
In fact, it did occur. And what happened is.
No, I don't know what happened, I just want to know if it occurred.
It occurred with the assistance of the Wyandotte Police Department.
I must state something for the record.
Okay,
Plaintiff was actually, I don't have a copy of a written order and I wasn't here, so I'm at a little bit of a disadvantage, of course.
okay,
Plaintiff, of my understanding, was in violation though because he brought 2 police officers with him. This woman's already being, sexually harassed by her landlord and.
hold on,
Sorry.
hold on
Sorry.
a moment.
For safety
Your
reasons.
your client had made allegations regarding various types of harassment or assaults, indicating that those are being investigated. I don't have any information or basis for any of that, so counsel, please, we're not gonna go there.
I'm not trying to bring those claims to this court. I'm trying to explain that under the order, and as you described it, there was supposed to be 1 independent person with each party. She's in significant emotional and mental distress because of her living situation. And then she has her landlord come with 2 police officers instead of an independent person. So plaintiff is in violation of what the court ordered. And it's having a deteriorous mental effect on my client, who's now being put through the ringer in court that, she's not credible because she's suffering from abuse.
Your Honor,
Well, first of all, I haven't said that your client's not credible.
Yeah.
I haven't said that at all.
Okay, sure.
But,
Fair enough.
may I address?
But I also, I will say from an outside perspective, that I don't know that there could be any more independence, as far as independent individuals than the police department, because they don't have any, stake in any of the games.
I appreciate that.
But the,
And she's
issue.
been made aware of that, but the problem is that it's a very tenuous situation and the court ordered that 1 independent person come. And that's not what happened. The landlord brought 2 police officers with him. And that was video camera evidence. Even though it's from the police, there's a cam, they wear a
Body
cam.
cam.
Yeah.
okay, when I said no video, I meant I didn't want each of the parties to video the other party, thereby exacerbating any issues that were going on. That is what this court was intending, because your client was improperly recording the proceedings when she was here last time as well.
I understand.
So I wanted to make sure that neither party was exacerbating any issues or trying to instigate any provocation from the other side. That was why this court ordered no videotaping of the other individual. However, they could take photos of whatever issues needed to be repaired, but they didn't need to have the other person in the video or in the photo.
If I may.
So my first thought is that if there's two police officers there as independent witnesses, because they don't have a stake in any of it.
Wow.
I'm not sure how there could be any more independence by that. Did your client have another individual there with her?
Honestly, I'm not sure, but she certainly didn't call the police. And if the order said you can have the police present, then I wouldn't even be discussing it. It's not that I'm trying to cause an issue. I need a simple adjournment. I need to get some fairness for my client. And
I'm not saying I'm not going to get the adjournment, counsel, but I'm just trying to understand if any of the things that this court had ordered occurred.
that's hard for me to know precisely.
Well, but I'm also going to say this, that I don't know that there's a violation of the order, of this court's order regarding, and really, I didn't say they had to have an independent person. I said they could each have an independent person. I didn't say that they had to have an independent, I didn't say they had to have anybody there. I said, if you choose to have an independent, a person there with you, right, because I thought that would probably be most beneficial for both of them, it has to be an independent person. And there are what they call civil standbys, right? So there's individuals that may be going to a property to, if the court ordered they can't return back to the home, they take the police with them to go retrieve some of their personal belongings or what have you. So I don't necessarily know that that's an improper person to have there during the time that the photos are being taken. I'm not sure.
Yeah. Guys, Judge, I think the reason she's objecting is because we've submitted the body cam of the police officers. Now, let me back up.
Wait, where did you say? Where did you submit the videos to?
Your Honor, Stewart,
No, Mr. Foley's on Zoom.
No, Mr. Harper.
Okay.
Mr. Harper.
Where did you submit the body cam to?
Your Honor, what we've done is that I've answered her motion to.
No, counsel.
It's part of
Where
it.
did you submit the body cam?
It's part of our response to her motion to dismiss. It was emailed.
Who filed the motion to dismiss?
My
Miss-
client filed an amended motion to dismiss.
And so
When
we,
did she file that?
Well, she does not understand the court system or e-filing, so I filed it as an exhibit because a brief was ordered. So my whole position is very convoluted. I have a brief and I have an amended motion to dismiss attached to it.
Your Honor, if I may,
Okay.
the motion was properly filed. It was properly filed, but not timely. You had ruled on that already. So you had a copy of the motion and then.
No. I didn't rule on the motion to dismiss. I said that I wasn't going to hear the motion because it wasn't properly, there wasn't proper notice. So I didn't dismiss the motion. I didn't do anything on that. I simply indicated I was not going to hear that on the 11th of February because it had not been properly noticed, there hadn't been proper notice. So I didn't rule on the motion. So let me just clarify that for the record. I did not rule on the motion.
That's correct, Your Honor. I wasn't inclining to say to you that you had ruled on anything. I was merely saying to you that when she appeared here in court, they took the motion and they filed it. And I was about to say exactly what you said, so I'm not going to repeat it. But in answer to your question, Your Honor, we had submitted a Dropbox that contains the body cam of the police officer, and it was emailed on Friday at the same time that we filed our responses to D. Peryaski, Paryasky,
Oh, yes. Yep.
Yep, at wine.mi.gov. And so the drop link that's there will allow the court to perfectly view the body cam video. And I think, let me tell you why you need to view the
Well, hold
body
on,
cam.
I'm going to tell you why I'm not going to view it right now, because it's not properly submitted as an exhibit to a motion. I'm not going to view a video that's just been submitted as a response to a motion, or that's been emailed to the court, because there's still the evidentiary rules that the court needs to follow, and that's not properly before the court right this moment,
May I address that?
okay?
Like I said before, this was in response to the motion to dismiss. And hopefully you'll take an opportunity, because I know this was filed late on Friday, to review all these documents between now and the next time we return. But in terms of evidentiary, Your Honor, it is not hearsay. It's not an acceptance.
Objection, we shouldn't be going into the details of the video.
I'm not
Sorry.
saying that.
With all due respect.
Hold on, the court's gonna overrule the objection, and the fact that, it's a bit premature, because there's not been a video offered for evidence at this point. I'm stating that the court's not reviewing the video right this moment that was submitted with your response. I don't even have that loaded on here. Potentially, because it was done late Friday afternoon, and there's, probably 15,000 steps that has to happen from the e-filing once it gets put into here, and Ms. Perioski is out ill, and so it's not on here.
I
So
understand.
I want to state for the record, I have not reviewed the video, nor am I going to review it right now, because I haven't had the opportunity to review the response, and there needs to be a review of the foundation before the court can view the video.
I agree with you.
So I'm not going to talk about whether it's excited utterance, whether it's not hearsay, or anything of that nature, okay?
In answer to, you had asked when it was filed, and we've answered it. You had asked how it was filed, and we've answered it.
Right.
And then the issue of whether it's admissible or not was raised. I was addressing that specifically.
Right, and I can appreciate that, counsel, but right now is not the time to address the admissibility of it, because I'm not hearing the motion right this moment.
I understand that, Judge. All right, so the next item I want to raise is the pragmatic part of this. In our response, we were able to locate the invoice in which my client first went to the city to apply, and it turns out it was in November. So this morning, I had my client go to the city again and request an inspection date.
Objection,
May I finish?
Hold on,
please don't yell at me.
excuse me. I expect that the attorneys are going to address each other respectfully and not yelling at each other.
I would like to finish my
So there's really not
statement.
anything to object to at this point, counsel. I'm just listening to what Mr. Dagger has to say.
I didn't get that.
This is the second time that's happened, and Your Honor, I just want to finish
What's the
my
second
statement.
time that's happened?
That she's objected in the
Okay, and
middle
I
of
just
sentence.
addressed it, so please continue.
Thank you.
Your client went to the city this
My
morning.
client went to the city this morning. My client was able to obtain, pardon me, Your Honor, there's a potential witness in the courtroom here who I think is going to be called. And what is your name? I'd like to identify
No,
who she is.
counsel, I'll find that out.
All right,
I'll find that out. Scott, can you go find out who? Actually, okay, Ms. Declala, who is this individual?
I don't know. I haven't seen the video. I don't know.
Yeah, counsel, I'm just asking, who's the woman that's here in the courtroom?
Oh, this is, someone who's assisting me.
She's assisting you?
Yes.
So she's not going to be a potential witness or anything?
No.
Okay, and what is your name, ma'am?
Ariel, I'm a friend of, Ms. Collins.
Okay, you're a friend of Ms. Collins, but you're not intending
No.
to testify?
No.
And so she's helping you out, counsel?
Yeah.
Does she work for you, or she's?
No, she's,
information using small business.
yeah, and also
I'm
I
sorry,
like,
what?
Filling her in on any facts that she might need because Ms. Collins isn't here.
Okay, well, Ariel, if she's called to testify, won't be allowed to testify then.
I'm not calling her.
No, I understand that. I'm
Yeah.
saying in the future or otherwise, because she's been inside here, so, okay.
but continue on, Your Honor. As I was saying, my client this morning went to the city and was able to obtain an appointment for next Wednesday between 9 and 2 to conduct all the necessary inspections for the compliance certificate. What I'd like the court to do if we're going to adjourn this matter, is that I would like an order of the court allowing all necessary inspections to be conducted by the city next Wednesday between 9 and 2 as regularly scheduled. We have no specific control over the exact nature. Now, Sister Council had mentioned that there's a statute.
Hold on, before we get to that,
Yes.
we're going to address this. All right, council, I'm not addressing, C of O, no C of O, or collecting rent at this point. I'm just asking, is there an objection to the city on February 25th between the hours of 9 and 2 p.m. to go to the home to inspect the property?
Yes, because they have to get in contact with my client first. In fact, I have from the city of Wyandotte, enforcement details. She submitted to them a copy of her lease. They were requiring that first. And under city ordinance, unfortunately, I don't have the point, but they have to get in contact with her directly. The city does. I would love to agree to that.
I don't understand what you just said. Do you, Your
The
Honor?
city has to get in contact with Ms. Collins.
Yes.
That's just not true, Your Honor.
Council, give me an opportunity, please,
Thank you.
without interrupting.
So this is from BSNA Online, and there's a summary here. There was a complaint, possible rental at the address. The tenant dropped off a copy of the lease and info for request. So now opposing counsel has scheduled the inspection.
Well, no, it doesn't sound as though you scheduled it. It sounds as though the city
Right.
told Mr. Branson when they would be there for the inspection.
Excuse me for misspeaking. It's my impression they have to contact my client in order to schedule it.
And, okay, your state, is there something in the ordinance specifically that says that the tenant has to be present or the homeowner has to be present?
I'm not sure, Your Honor.
May I read the statute, Your Honor?
Okay. You have the ordinance there?
No, Judge, I'm reading the statute she cited to me outside.
No, I'm not talking about.
Well,
the
there is
statute right
no
now.
such ordinance.
Well,
There is no such ordinance.
hold on. Council, Mr. Klala, I'm sorry. You stated that your client is required, that the city has to notify your client.
Yes.
Okay, where is that authority?
I'm not sure.
Okay, but you made that statement, so.
I did, yes. There is a statute, that's a state statute. However, I'm not sure the ordinances. Again, what I was saying before was coming from BSNA Online. But under MCL 125.526, that took effect in February of 2018. It was actually narrowing what could occur during municipal rental inspections. And those are actually exceptions. So they can't go in if it's vacant, they can't go in if it's responding to a tenant complaint, or if the municipal inspector has a warrant for the inspection. So my tenant did complain. This is an inspection that's being scheduled by the plaintiff, which is perfectly acceptable in my eyes, but I don't want to violate the fact that she's due notice under this statute.
Okay, just one moment here.
She's citing,
Hold on, council, just one moment. I pulled up 125.526, so please pull it up.
direct your attention to paragraph 7, Your Honor. It's actually paragraph 7.
Hold on, council, just one moment. Except as provided in subsection 7 to 9 and 11, an inspector or team of inspectors must request and receive consent from the lessee to enter before entering a leasehold regulated by this act to undertake an inspection. So we'll read 7, 8, 9, and 11. 7, the owner of a leasehold shall notify the lessee of the enforcing agency's request to inspect a leasehold, shall make a good faith effort to obtain the lessee's consent for an inspection, and if the owner obtains the lessee's consent for an inspection, shall arrange for the inspection by the enforcing agency. 8,
An IQ of 85 to 115 is considered average in the U.S., and IQ of 115 to 145 is considered high, and an IQ 145 is considered genius. Are you curious to know where you stack up? You can take this 2-minute IQ test. That will give you detailed results on your
The owner of a leasehold shall provide the enforcing agency access to the leasehold for an inspection during reasonable hours if any of the following apply. A, the lease authorizes an enforcing agency inspector to enter the leasehold for an inspection. B, the lessee has made a complaint to the enforcing agency. C, the leasehold is vacant. D, the enforcing agency serves an administrative warrant ordering the owner to provide access. E, the lessee has consented to an inspection, or subsection C. If a lessee is not present during the inspection, the enforcing agency may rely on the owner's representation to the enforcing agency that the lessee has consented to the enforcing agency's inspection. So it doesn't appear as though any of these apply. I don't have a copy of the lease that would indicate whether or not the lease authorizes an enforcing agency or the city of Wyandotte inspector to enter the leasehold for an inspection. However, the lessee has made a complaint to the enforcing agency. So that seems to trigger the owner being permitted to provide the enforcing agency access to the leasehold.
That's correct.
That would be 8B.
That's correct.
And then let's see, 9 is the lessee shall provide the enforcing agency access to the leasehold for an inspection during reasonable hours if any of the following apply. And then that's 4 of the previous 5 as well. And then 11, before entering a leasehold regulated by this act, the owner of the leasehold shall request and obtain permission to enter leasehold. However, in the case of an emergency, including but not limited to fire, flood, or other threat of serious injury or death, the owner may enter anytime. So it appears, counsel, that under MCL 125.526, 8B, Mr. Branson has authority to allow access to the home during reasonable hours. And 9 a.m. to 2 p.m. seems as though those are reasonable hours.
Thank you for the clarification.
Yes.
Are you recording, ma'am? Your Honor, I think
Hold on, ma'am, are you recording these proceedings?
No,
Okay, where's your phone?
it's stand up.
Okay, please present it over here for a moment. Okay, here's what I'm gonna ask you to do. I'm sorry, no, hold on, Dave, I'm sorry. Can you please, enter your passcode? You don't have to show your passcode to the court officer, but put it in a spot just so that you're only entering your passcode and nothing else, please.
I have to count it first.
It's completely off?
Correct.
Okay. All right, I'm just gonna, so it's completely off?
Correct.
Okay, please hand it to the court officer for a moment. We'll leave it up this way. You'll get it back you'll get it back when we're done.
Oh, wait a minute, no, you can't take my phone from me,
Yeah.
because you're not authorized to take my phone from me.
Yeah.
I'm not violating any rules.
Yeah,
I would like my phone back.
yeah, all I'm doing is just making sure these proceedings are not being recorded.
Correct, and they're not, I have not reported them.
Yeah, I'm just indicating it's gonna be here for just a couple moments,
Oh,
and then you're gonna get it back. I'm not saying it's for hours, no, as soon as we're done with this, you're
no,
gonna get
I
it
want my
back.
phone back. The court is not authorized to take my phone.
Yeah,
Under what basis?
because there has been previous recordings.
Not by me.
Can you please not interrupt the court? By Ms. Collins, there is a concern that the proceedings are being recorded. So I'm just trying to alleviate any of the concerns, and it's just going to temporarily stay right here. That's all I'm saying.
Can you please, under what law that gives the court?
Under the judicial discretion that's given to the courts under the court rule that allows phones to be brought into the courts.
That you can take my property?
The court has judicial discretion as to whether or not to allow individuals to keep their phones. If you want to go put it out into your car, you can certainly go do that. It's just not going to be in the courtroom. So can you give her back her phone? You can go put it out into your car.
So because I'm friends with Ms. Collins, you're concerned that I will be recording?
No, ma'am, it's not because you're friends with Ms. Collins. There was a concern raised that there's potentially recording. You stated that your phone is off.
It is off, so how could have I been recording if you make it pay? I looked up here, my phone
Ma'am,
is shut off.
Ma'am, this court has judicial discretion to ensure that there isn't anything improper occurring regarding any recording.
Correct,
Okay.
and it isn't.
Ma'am, it has been raised, so all I'm doing for purposes of the proceedings is for you to go take the phone out to your vehicle.
Caesar Milan, how to add years to your dog's life. Sardines.
9.
I'm not arguing with you any further. I've explained the court's position, you can go out to your vehicle.
I will take it up from you.
Okay? So, pursuant to MCL 125.526, 8B, the inspection is scheduled for February 25th from 9 a.m. to 2 p.m.
I'm sorry, it's 26, Your Honor.
You said the 25th.
My mistake, I misread it, it's the 26th.
26th,
26, correct, 226.
okay. I prefer for everybody to come back Friday because the inspection itself, I'm not saying it's a moot point because obviously the property has to be inspected. But for these purposes, I don't know that that has a bearing one way or the other with what this court's ruling regarding the escrowed money. Because I believe that the issue that we have left to address is where does the escrowed money get released to whom does it get released? And Ms. Collins raised a concern regarding overpayment of the utilities. And so there's that issue. So counsel, when the two of you were out in the lobby waiting for the court to call the case, did you go over any of the utilities?
No.
No, Your Honor. Well, we can try to address it before the hearing on Friday.
Okay, I mean, since you're here, you might as well, while you're out in the lobby.
We can.
Maybe look at it, or you can
But
maybe
the
go
problem
over to
is-
the offices.
Ms. Collins isn't here, and because she's not here, I haven't been able to get anything directly answered. So I don't know how constructive it would be.
Well, counsel, were you provided any utility bills?
I was, I might need a moment and I might have to do it over the phone because there is some aggression outside in the hallway and I'm not comfortable.
I'm sorry, aggression?
Yes. I don't know how much I'm allowed to disclose because it's settlement negotiations.
I'm sorry.
Okay, all right, your aggression by,
Opposing counsel,
okay, verbally?
physically,
Oh, my Lord.
Okay, what specifically?
he was stepping, the woman, Lily, who just left the courtroom, you know, even if she shouldn't be involved in the conversation, I respect this, but he was physically stepping in front of her and pushing her back. I witnessed it.
That's not true, Your Honor. That's
It
a
is.
false statement. That is a false statement, Your Honor. We were having a private conversation. This young woman comes up and starts interrupting, getting into my face. So I turned my back, not wanting to confront her, because I didn't want to deal with it. You can see why from earlier what happened. I just don't want to deal with it. It's me and her. She's a very kind human being. I don't see any reason why anybody else can be involved in
Referencing Mr. Kalala.
I am.
For the record.
Yeah, you know, we've talked on the phone. She's a tenant in the building I built. The guy she works with is my childhood
This
friend,
is not
Scott.
relevant.
It is very relevant. Finish,
No,
please.
listen.
Man, they're just producing issues for no reason at all. I'm willing to have any conversation with anyone, particularly Ms. Dakala, because I view her as a very kind human being. And I'm not sure where this hostility is coming from, other than the distraction for further noise.
Okay.
And that's something that
Hold on.
I'm trying to avoid.
Here's what I'm going to say. So, Miss Ariel or Miss Lily, I'm not sure what her name is, I thought she said
Ariel, I'm sorry, Ariel.
Oh, okay, she really has no point really in participating in the conversation between you and counsel. But what I'm going to say is we have a court officer that can be near the both of you if, you know, for some more, so that you can feel a bit more comfortable.
Okay.
So we can do that,
If
because
you
I
could
do
be-
think it's imperative that as much as it can occur for counsel to be in the same room showing the paperwork that's there to be shown on both sides, as opposed to, you know, getting an email or talking on the phone or something like that. So if there was a court officer that's there, would you feel more comfortable with that?
A little bit, but frankly, you know, opposing counsel is a fantastic order, but I'm shaken up. I'm shaken up, you know, and not trying to cause a distraction. I can't deal with that, an overly aggressive person outside of the courtroom, even if it's, you know, when people aren't looking. If it's over the phone, fine. If it's words, fine. I know that Miss Ariel is not my technical assistant. I know that she's not technically involved in any aspect of this case as a party, but I don't feel well internally. That's the problem. And I need to go forward on this motion, this amended motion to dismiss, but I can't tell my client that she can't be here, can't participate. If she's insisting on being here, I have to respect that.
I didn't say she couldn't be here.
Right, and I know you didn't. But what I'm saying is that, to me, it's very clear what the situation is, and that if there's an eviction action, it needs to be done differently.
It's very clear.
Yes, I'm not gonna get into the substance of the matter of the amended motion to dismiss.
Okay,
I don't know what she's,
well,
I
okay.
don't understand what's going on here.
So
And
everybody can be back Friday?
Yes,
ma'am.
what time?
Your Honor, there's just one issue.
Hold on, let me, well, okay, does the issue affect Friday?
It does. Let me tell you why. If the court decides to see the video, we were told by the court clerk that we can't bring with us a stick that you can plug in. But what we've done instead is that we put it into a Dropbox. And I'm hoping, and I brought my assistant Ashley because she's a lot more sophisticated with technology than I am. And so the only reason I've asked for her to be here is to facilitate showing the video if you decide to see it on the screen or multiple screens, however the system works. So that's about the only technical issue that I'm concerned with. I don't know how to do that, Judge. But if you know how to do it.
Your assistant can't be here on Friday?
No, Your Honor, she's going to Florida.
Okay, well, it's just about just make sure she has it saved on your desktop, and that way, when you do your screen sharing, you can access it and pull it on up.
Well, I was going to ask the court, since we emailed it in a Dropbox to you, would you be able to do it yourself here?
That's not what we do, and I'll tell you why. Number one, and even though it may have come from the police department through the records, it's a way to make sure that we're not getting any viruses into our equipment. So, no, I'm not going to play it on my device.
She just suggested an idea, if I may.
What's that?
She can appear by Zoom if it's possible, and perhaps we can do a screen sharing, and then it can be demonstrated on screen through screen sharing. Is that possible to do?
Yeah, that's fine. I mean, the sole purpose for your assistant is to play the video, correct?
That's right.
Okay.
I don't know how to do it, Judge. And in other courts, in circuit courts, we pre-arrange it. So what happens is that some sort of a cord is plugged from from the computer to the screen, and it plays on the screen. That's how we've done all the other video. But, you know, when I started.
I don't think there's a cord long enough for, I don't know.
When I started college, Judge, I swear to God, they weren't getting any computers, they were using cards. And by the time I graduated, we got into the PC. So I'm not technically savvy. But at the end of the day, Judge.
Change with the times, Mr. Dagger.
Judge, I'm retiring next year. I'm almost 60. I don't really care. And I'm going back to the farm in South Lebanon and raise chickens. Think I'm kidding? It's true. I'm not joking. My grandfather lived to 95, and I intend
I'm sorry,
to follow his
can we limit the extra comments?
So,
Your Honor, with all due respect, counsel here has demonstrated a great deal of agitation to me, and now I'm in fear.
what are you in fear of, Mr. Dagger?
I'm in fear of being anywhere near counsel and being accused of something. So I'm just letting you know on the record what I'm now fearing. I'm sorry that I'm a man and that I am who I am,
Gender has nothing to do with
but
that.
that's what she was suggesting, Your Honor.
No.
Okay.
Anyway, Judge, we'll be back on Friday, what time you said?
May I request that it's at 8:30?
Let me just double check what the docket is.
Okay.
I'm here all day, I don't have anything I'm presenting, so let me check what the docket is.
We're okay for 8:30, Your Honor.
Well, I mean, we'll do 8:30. There may have to be some interruptions where I have to move people in and out of breakout rooms and such, but we'll do 8:30. Everybody can be here at 8:30?
Your Honor, is there a Zoom login information that we can get now?
Yes, just one moment. Well, let me just confirm. I know I just said that there's, okay. So, 8:30 a.m. I'm going to ask that you both email me the briefs that were submitted via my file, just so I can have those to review in the event, I'm not sure when Ms. Perry-Askew is returning. So please email those to review. Please email to me the amended motion to dismiss and your response, Mr. Dagger, plus the video.
Your Honor, I actually did attach the amended motion to dismiss as an exhibit to my brief. Do you want me to do it differently, or is that sufficient?
Did you draft the amended motion to dismiss?
No.
Okay. No, that's fine, that's fine. You can just say the way it is. Mr. Dagger, though, I need the response, if you can email the response and just remove the video from the attachment.
We'll do that, Judge.
I'm sorry?
We'll do that, Judge. You also wanted the memos, I assume, Your Honor? You asked us to brief?
Yes, so that's what I did. I asked both of you to email the briefs that you submitted.
What's the email address, Your Honor?
27dc@wine.mi.gov.
27dc.
dc@wine.mi.gov.
You should already be copied on an email from me to that email address.
And then the Zoom ID is 656-647-7075.
Is there a password, Your Honor? No password, okay. Can I repeat that to you, Judge, just to be clear? 27dc@WANDOTTE.
Wait, W what?
WYO, is it YAN? Yeah, sorry, WYANDOTTMI.
There's an E at the end of the.
TTE.mi.gov, correct?
WYANDOTTEMI.gov.
Got it, you got it.
Okay.
And the Zoom is 656-647-7075, correct?
No, 707.
Okay, she's got it.
I got it.
She's the one that needs it, so, okay. All right, and if you have any questions on that, it's on our website as well.
All right.
Okay.
Thanks again for all your patience.
So Judge, in terms of the inspection, it's not going to be in written form. Do you want us to submit it to you? We can do it now if you want.
Submit what, the
The
communication from.
order of inspection. We can prepare relatively quickly and submit the signature. So that,
Oh, you can bring it on Friday, that's fine, because it's still before Tuesday,
yes, ma'am, we'll do that.
okay?
All right,
All right, anything else?
No.
Okay,
thank you, Judge.
all right, thank you. Have a good day. Let's
You
go
too.
off the record for a moment.
I'm not talking to you.
We've got utilities on Friday. Please bring all the documentation with you.
May I?
Hold on, let me go back on the record.
Okay. What we can do, Judge, with regards to utilities, I can have my assistant talk to her directly, or we can exchange emails. I won't be part of the conversation. I don't want to be physically in any place near her. So I'm offering her an opportunity to suggest she can talk to my assistant Ashley, or we can go back and forth in email. I'm not quite sure what would be more efficient.
Well,
In 32 years of practicing.
hold on, I'm not gonna get into getting into all the dissertation. Do you want to speak to Ashley?
I would speak to anyone. I just, I mentioned he's being physically aggressive and now it's being pushed over onto me somehow.
Who's
So
pushing
I
over
don't-
on you? I mean, the court's not pushing over.
I just was no, not the court, opposing counsel. I was just mentioning I can't talk to him outside right now. I need a second to breathe.
I don't want
What
to
about,
That's all.
please, hold on, what about speaking with Ashley? And the two of you can go over the utilities and kind of see where you're at. And then Ashley can get her steps in, go back and forth with Mr. Dagger, somewhere where he's somewhere else, and the two of you can have a conversation, you meaning you and Ashley, can have a conversation regarding the utilities.
I have a panic disorder.
Okay,
Yes, I can go sit with Ashley.
okay, all right, so
I'm gonna
Ashley,
stay here.
I'm familiar with everything in the case and I would also hear this.
okay, and then if there's any
I will go
questions,
back.
whatever, I'm gonna have you go back and forth with Mr. Dagger.
Yes,
But if the two of you have to have a conversation, then I'm gonna have the two of you, have that conversation outside the presence of, Ms. Teklala and Mr. Dagger. I'm gonna have you, cause I have some other matters that I'm, handling here. So if you have to have a conversation, then you have to step outside.
What I'll do is I'll sit next to the court officer, Your Honor, near the entrance, and I'll sit there and go back and forth.
That's fine.
I'm
We can open
not
up,
interrupting your court.
we can open up the, either the defense attorney room or the prosecutor room, so the two of you have a desk.
Okay, thank you.
Okay, thank you. We'll see you both we'll see you all on Friday. All right.
Thank you. Better leave first, please.
Where would you have to go? I'm sorry. The incredulous behavior that you've exhibited by recording these.
Do not dare say
Again,
that to me.
you are interrupting me once again.
Your Honor, you just gave me the finger. I'm looking at the screen.
Hold on, right now. Don't interrupt my record. Do not interrupt the record right now. Both of you, please stop.
She said that she's seen your picture as part of a swingers club.
I
While we
never
were
said
standing
that. Listen, this might be laughable, but I will admit what I said. I had no.
All right, so we are on record in the matter of William Branson versus Heather Collins, 2402269. And counsel?
Good afternoon.
Appearance, please.
Good afternoon, Your Honor. Highly Dagger, bringing half Mr. Collins, Mr. Ransom, who sits to my left.
Okay. And ma'am, your name, please.
Heather Collins.
Okay. So today is the date for the bench trial in this matter. Let me swear both your client in as well as Ms. Collins. I'm gonna try to, I'm gonna see if we can do this a little bit less formally to see where we get. So sir, please raise your right hand. Ma'am, thank you. Do you both solemnly swear from the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yes, Your Honor.
Okay, so I wanted to state one thing is that my court officer informed me that he knows your client, counsel. I didn't inquire as to how he knows him, but I will say that I don't know I don't believe that affects my ability to be unbiased, but I wanted to place that on the record in case anybody had any questions that they wanted to ask, or if they wanted this court to disqualify itself.
I do. If I might want this to be brought down to Wayne County,
Well, it wouldn't be Wayne County, it would be another district court.
then yes, it might be. If it's not gonna be dismissed off of the motion to dismiss, then I do want it brought to a different court.
Okay, on what basis, ma'am?
I already know he's told me in the past that he has the judge in his pocket and the police officers in his pocket. I have a box of text messages saying that to me.
Okay, so let me just clarify one thing. Sir, do I know you?
No, ma'am.
He's been in front of you many of times and I have.
Hold on,
records to show that.
ma'am, hold
Yes.
on just one moment. You made an allegation, so I want to clarify that for the record, because I don't know that I know Mr. Branson.
Yes.
Sir, have you been in front of the court before?
No, ma'am.
Yes, I'm gonna say 20-some years ago.
So it would not have been in front of me.
No.
It was not in front of me.
Yeah.
When you were a member of the city council,
Was I a member of the city council?
you signed off papers on him to do side work and he actually submitted that and you were the one who signed off for him to do property work on his house.
Property work
Yes, he actually submitted that in his own evidence.
that I signed off for him to do
Yes.
maintenance on his.
Yes, Your Honor. I have copies of the paperwork.
Okay, let me take a look at that paperwork, because, I mean, if I. And Mr. Branson, how do you know my court officer?
A longtime family friend from years ago. I haven't had any
Let's see, DiSanto right there.
15.
Okay, so you know who each other, you know who each one is, but you haven't had any communication in the last 15 years?
No, easy, yeah, no.
If you go to his filing that he submitted himself, okay, I'm just saying.
Please stop, just one moment, okay? All right. Okay, so ma'am, this is a zoning board of appeals and adjustment. I do not sit on this board. This is my husband who sits on this board. And I can 100% tell you that we do not discuss anything that he does here. This is definitely not me. I've never sat on a board, a zoning and appeals board. And this is from 2009, so I can tell you 100% that whatever this would have been, I have no idea. And I will also state that member DiSanto abstained. There were two members one that abstained, one that was absent. So I don't know why he would have abstained. I have no idea, but I can tell you that I did not sign off on anything.
Your Honor, I'm just going off of what he used to tell me, and in the text messages I have, where he said I have the judge in my back pocket.
Okay.
Your Honor, again, that's simply not true.
Hold on, let me clarify something. Sir, do you know my husband?
Personally, no.
Okay. So, ma'am, I will tell you right now, I do not know Mr. Branson.
Yes, okay.
So do you have any issues with this court continuing?
Not at this moment.
Okay, well, I would say that, that if something different comes up and it's shown that somehow I know Mr. Branson or somehow, then perhaps we can revisit it, but moving forward at this point, I find that I can be unbiased.
Thank you.
And I don't know Mr. Branson, and Mr. Branson knows, my court officer, but they haven't had contact for at least 15 years.
Thank you, Your Honor.
So.
I appreciate that, Your Honor, for you being honest.
Okay, so and I will also say too, in smaller towns, right, you're gonna have that crossing and such, but, you know, as I learned in new judge school, that judges are elected to serve, and they have to sit and reside in the community that they serve, and so sometimes there's going to be people that they know, so it all just has to be disclosed on the record.
May I just be frank a moment? I'm just scared because in my text messages, since I've lived there, he has said he has police officers in his pocket, he has a judge in his pocket. That is just where
Let me see the text message you're referencing, please.
No, I will find it. I have 2 full boxes that I've printed out.
Okay, I'd like to see the message that's.
I will have to find them, but.
Okay, I'll give you a moment, go ahead.
I don't know if it's in these. I can pull them up off my phone too, if it's not in the ones I printed off here. It might be in the ones that I gave you.
Okay, you said gave me, you mean in your filing, that the motion?
Yeah, I didn't print off the entire text chain, but the police also have them too, because we found out he wasn't a police officer. That he's never been a police officer, that he's told me, but we could continue, that's neither here nor there.
Actually, no, Your Honor, she said she just represented under oath to the court. She made a statement, an affirmative statement about.
I just wish she could.
Ma'am, you can't interrupt. Okay, just one moment.
At this point in time, Your Honor, she's sworn under oath, and you've asked her for those documents, now she's backing away from it.
Oh, no, we're not stopping, I need those, I wanna see.
Okay, I'm trying to find them right now, I have stage 4 cancer and I had a surgery, Your Honor. I'm saying if I don't have them here, then they're on my phone.
Okay.
I would like time. And if I can't
I'm
find,
giving you some time right now to look for those.
I have over 1,000 pages here. I'm just saying.
Okay, then do you have your phone with you?
Yes.
Okay, pull up your phone, and then on your text messages, when you pull it up.
May I sit down a moment? while I do this?
Absolutely,
Thank
you can do a
Yes,
search,
Dr.
absolutely.
Thank you.
You can do a search for the name Pocket, or search.
I don't know
for
how
Pocket.
to do all that, ma'am. I have a 2010, an iPhone 10.
Actually, you can just go to your text messages, you can hit search, and you can just type in a word, and it'll pull up all the text messages that have that word in
The
it.
police are going through my phone because he has gotten into my phone, Your Honor. The police have, I have a police case against him right
Hold on,
now.
yeah, right now I'm not worried about that, I wanna know what that says.
He's been editing my phone, Your Honor, is what I'm trying to tell you.
Ma'am, please just take a minute, or 2, or 5, and look for that, please.
I will. But I'm just saying, I was
I don't
thinking motion to
with
dismiss.
no more commentary.
Your motion to dismiss doesn't mean anything.
I said no more commentary. I haven't gotten that far yet. You've made an allegation and I want to see what that message is. And did you do a search?
I am looking right now. It won't let me do a search. So I have to look through the entire text feed.
Do you know what month it was that he stated that to you?
When I first moved in,
Which was when?
back in June.
Okay, so it's just going back to June?
Yeah, that's why I've been terrified living there.
Okay, ma'am, I didn't ask for all that. I'm just asking if you went back to June.
Yes, I'm all the way at the beginning of the text feed. That's why I said we can move on. I'm fine.
No, ma'am, we're not moving on until I see that. Did you find it yet, ma'am?
No, ma'am, I'm still looking through all his comments he was sending me. Mayor, Your Honor, it's honestly gonna be a moment. I honestly am not trying to lie to this court. It was said to me.
You made an allegation, and it's on the record, and so I would like to.
It is on the record because it was said.
Ma'am, I'm just gonna let you know right now. I'm not gonna have the continued interruptions. You made the comment on the record, the allegation on the record, so I want to address that on the record. That is what I'm saying. Because I can assure you that in the event anything like that was said, this court's not in the back pocket of anybody. I don't even know the plaintiff, as was already established. Okay, well, while you're still looking for that, I'm going to ask a few questions. Ma'am, you have been residing in the home since June, correct?
Correct, Your Honor.
Okay. And what is the monthly rental amount?
$1,500.
And counsel, what is the tribal issue that we have?
Your Honor, there is a trial issue. There was a $500 balance in November.
Oh, November, okay, I'm
Yes,
sorry.
ma'am.
$500 partial paid with a $1,000 balance in November.
That's
You said
right.
December and January and February have not been paid?
Have not been paid, but I verified earlier today, per the court's order, she had made $5,500 deposit into the escrow.
So then the only thing that you were looking for was the rent that was not paid.
Correct.
And so,
And utilities.
And utilities.
well, hold on, that's not on the complaint. On the complaint, it says $625 and it says late fees. So, and you're withdrawing your late fees.
Correct.
Okay, so it doesn't have any other allegation in here other than the unpaid rent.
That's correct, Your Honor. We will withdraw the allegations regarding the utilities. So the only thing we're seeking, in fact, are the rent, just the rent.
Okay, now, December and $1,500, so that's $5,500, so $5,500 is due and owing, and Ms. Collins has deposited $5,500 in escrow.
Correct.
So, once your client gets that, rent's paid in full.
That's correct.
Okay, so Ms. Collins, you filed two motions, so I was actually asking those questions because I wanted us all to be on the same page with what the issues are. So you filed a motion to dismiss and an amended motion to dismiss, and then you've also filed the motion to suppress the exhibit list. Now, I will note that this matter was scheduled for today, and that these show that these were filed on Wednesday. Well, one was filed January 31st, which was the motion to dismiss. The amended motion to dismiss was filed February 5th, and then the motion to suppress the exhibit list was filed February 6th. Those weren't filed timely to be heard today with the court because there needs to be proper notice, whether not only to the court, but also to Mr. Dagger.
You got it.
I'm sorry.
It goes both ways.
And so when you made the comment, ma'am, that your motion must not mean anything, that's not accurate. We can set it for a motion hearing later on, as far, it has to be filed at least 7 to 10 days prior to the hearing, depending on how it's being filed, okay? So, but it appears as though the rent has been paid in full, so what is the issue?
Your Honor, he doesn't have a certificate of compliance by law and Wyandotte law. He cannot collect rent there.
Okay.
And the reason he doesn't have it, Your Honor, is because he's attempted to obtain it over the past few months.
Hold on, I'm gonna get to you, ma'am.
We went back and forth. In order for it to be scheduled, you've got to be able to specify time and date for the inspection to occur.
Okay,
She's refused to allow the inspections to occur. This issue of certificate of occupancy has never been raised before until after the eviction's begun. And as such, it's sort of a mood issue. Notwithstanding that the law, unlike what she claims, does allow the rent to be collected. And it's a question of fact for the court whether or not the place is habitable. The issue of rent abatement is related to rent habitability.
Hold on, just a moment. I'm not necessarily talking about abatement.
Yes,
But I believe, if my memory serves me correctly, if somebody has a temporary C of O, they can collect rent. If they don't have a C of O, they cannot collect rent, is what I recall. Nevertheless, ma'am, has there been attempts, and this is a yes or no answer, have there been attempts to schedule an inspection with the City of Wyandotte Building Department?
No,
Okay. Mr. Branson, do you have any communication from the City of Wyandotte that has attempted to schedule an inspection?
Verbally.
I do not need any comments, ma'am.
thank you,
I'm talking to you.
sorry.
Verbally, I talked to Callie at the engineering office and basically she said, you have to give me a date so we can get you scheduled. Knowing she had health issues and things, I tried to communicate with her, starting back in December, saying, when's a good time to get in?
Okay,
Yes.
pause on that. Who has proof of those communication? I'm gonna guess you do since you have 2 boxes of text messages, correct?
Yes, Your Honor.
Okay, I'd like to see the communication between you and Mr. Branson regarding scheduling for the
Your
inspection.
Honor, I have something better.
Hold on, first I wanna see those text messages.
He never went to the city back in December.
Yeah, first let me just see the text messages, please.
I can show you my phone.
No, you said you printed them off.
Yeah.
Okay,
I said if somebody was in my house, he could come over. He then never wanted to come over.
yeah, right now I just wanna see the text messages, please.
But it wasn't for the city, never once for the city.
Ma'am, please.
Your Honor, while she's researching it, may I add something about the law?
No,
Oh,
just a
wait.
moment.
Yes, ma'am.
Man, these are out of order, the December ones are not.
Okay, is it on your phone?
Yes, I'm gonna pull them up. December 23rd, he
Okay,
said,
no, I'll take a look at your phone, please. You can show counsel and then, counsel, I'm gonna look at that message there.
Your Honor, I'd like to see the before and after conversation.
Okay, well, first I want you to look at the December 23rd.
Mhm.
So, ma'am, if you can show Mr. Dagger the December 23rd message.
this is from him.
This is from him, okay. Can I see the prior message, please?
This is from him on the 23rd.
Can I see the prior message?
This is from him on the okay.
No, stop. I'm not gonna have you arguing. I said right now, just the 23rd.
Thank you, Your Honor.
And then counsel, I'll review that and then I'll move from there.
So this is your message to him?
No, this is your message from your
So this is
person.
my client's message?
Yes.
Thank you. You're showing me what you want to show me.
No, I'm not.
Counsel, listen, I'm telling both of you right now.
I'm showing
Right now, stop. Right now I said just show the 23rd, right there, that one message. And then I'm going to go from there, counsel. I'm very familiar with messages that are deleted, not deleted. There's things that go before and after. So right now I just want to look at the 23rd that she found and then I will go from there. I don't need any more commentary. Counsel, did you look at the 23rd?
Your Honor.
I'm still showing him the ones on the 23rd.
No, just the one. How many are there?
Well, there's my responses back to what he sent me
Hold on.
about that message.
I read my client's response, Your Honor.
No, that's all, I'm sending him the one he sent me about the inspection.
Okay, that's
And
what I
my
want to see.
response.
Let me see the 23rd.
And then I was gonna show my response to
After that,
this.
after I look at this one, then you can show the response.
And that's the first time he ever brought up an
I don't need
inspection
any
to
more
me.
talking right now, please. On December 23rd, 24, we will change the filters during the city inspection that is scheduled for January. Time will be determined by the city, business hours is in parentheses. There will be 4 inspectors plus myself and must have access to all rooms and storage spaces, i.e. closets and pantries. We are sorry for the inconvenience and have a happy holidays. Now, I'm going to scroll down, I'm going to read the message right before that, which that's in green, so that is from Ms. Collins. Obviously, there would be a penalty because you're not willing to give me my security, so don't act like you're trying to be someone nice when you're not. Why are you bringing an officer into this when I told you I'm going to be having someone here? So stop it now. If you want to fight with someone, continue it with your wife. Leave me alone today. Prior to that is from your client. There's a matter of 4 messages. We won't be coming into the office, get here, and then next one, officer with an asterisk. I'll be testing the locks to ensure they work properly. I don't understand, this is such a horrible environment, why you wouldn't want to leave, especially with the accusations you've made. We are willing to break your lease, no penalty. Prior to that one, this is from Ms. Collins. No offer needed, I have someone coming. I'm not resending a list I sent a million times, I stated before. You said you saved all your messages, relook through them. I'm not playing your games, I'm not sending another text message to you. I need to save my strength. I'm not sending another text message to you again. I will see you on Monday at 6:30, goodbye. Do not come a second earlier, I will call the cops breaking in. Really? And
He
it's
comes in
6:30
whenever he wants
don't-
to.
Stop. And it's 6:30 PM, to be clear, because we both know how you twist things. Do not use key, I will open door or I will change locks. Prior to that, and that was in response to the message from your client. Actually, I'm gonna go 2 back, I'm gonna go a few back. Okay, starting December 21st. Good morning, is there any this is from your client, counsel.
Yes, ma'am.
Is there any possible way we can meet a mutual agreement that we can get into the house and change the furnace filter? Start up the humidifier on the furnace, change washing machine discharge filter and check the GFI, the kitchen. No arguments, we don't even need to have a conversation. I just need to make sure everything is operating properly so you don't have a breakdown when it gets colder. Kate and I will be coming in together so we can get out of your hair faster. I would like to do it either tomorrow or Monday evening after 4. Also, has the bathroom sink filter been cleaned? And Ms. Collins responds, it won't be until after 6:30 on Monday when I have someone with me. And the bathroom breaker needs to be fixed as well. If you're not willing to fix everything, then don't fix anything, clean and simple. There's more than just a problem on your list that needs to be done. And Mr. Branson responds, we will be there 6:30 on Monday, thank you. I'll bring a GFI to replace if needed. And Ms. Collins responds, I said, only if I find someone to be here with me, please don't misread that. No, ma'am, you said when you have someone with you. Let me clarify. You said when you have some, that's in your message. And then Mr. Branson says, please read your lease, thank you. And then Ms. Collins says, I will not be alone in this place with either one of you. I don't care, I feel unsafe and my life is more important, facts. Mr. Branson responds, them, you are refusing, correct? I'm giving you 48 hours notice for the record. Ms. Collins responds, I have you on tape saying you don't care if I feel unsafe. Conversation done, you are not allowed in unless someone is in here with me, so no, do not come in. To which your client responds, then have someone there with you. This is your written 48-hour notice. Ms. Collins responds, no, in all caps. Mr. Branson responds, thank you. Ms. Collins says, call the cops, I don't care anymore, in all caps. Mr. Branson says, all I needed. Ms. Collins says, I will put my safety before you, plain and simple. I feel unsafe around you. I feel in danger around you. The words I have on tape that you said that came out of your mouth is all I need. Okay, and then there's some allegations I'm not going to read into the record because I don't know what basis that is or not. And then Mr. Branson states 6:30 Monday to get combinations done. Ms. Collins says, plus some of the stuff I paid ready to get fixed because you refuse to fix them that I've asked for months. Mr. Branson says, send me proof in a bill. Ms. Collins says, I will have every door locked. You will not be coming in at 6:30. Mr. Branson responds, I have keys. Ms. Collins states, just like you not sending me proof of bills, I don't need to send you anything. I will be seeing you in court. This will be my last message to you. Mr. Branson says, by law you do. I will be there with my key at 6:30. Just so you know, in your safety, I requested a civil standby with line out police at 6:30 on Monday. An officer will witness everything. Please tell me a list of everything needed to be addressed and repaired so we can inspect and address. Also, bills for said repairs so we can inspect and address. Thank you. And then that's when the message that she said she's not resending a list a million times that she sent that. Wow, so you're watching my every move. This is from Miss Collins. Why should you watch everything I do? That is beyond so creepy. I purposely only throw all my trash on Mondays ever since you told me you go through my trash way back the first month I moved in. Do you go through your trash?
The trash goes into a community bin, I put the trash out, so all of our trash goes into
Okay.
one bin.
Yeah, I was asking, Mr. Branson, the property, do you all live on the same property?
Yes, ma'am.
It's a duplex, Your Honor.
Okay,
It's a duplex with first floor and second floor in each unit,
okay,
with a common basement.
okay. And so ma'am, you've been residing there since June, correct?
Yes.
And so if you're having all these issues, ma'am, why do you want to stay there?
I don't. I've been wanting to move. I've been trying to move. They won't give me my security deposit back. Back in November, they told me they were gonna raise my rent $400 a week. I have text
Ma'am.
messages.
Ma'am, what steps have you made to locate another place to live?
I have been looking and searching. I could show messages of every single property I've gone to look at. But without money, because I have to pay rent here or not put it into the court. And they will not, I've asked for my security deposit back. They have offered for me to get out of my lease, but they say, we won't give you your security deposit back. Because that's me breaking my lease.
Your Honor, if I may,
Yes,
I happen to have been the attorney that evicted her from the last.
I'm sorry?
I happen
You
to be.
cannot bring that in,
Ma'am.
because I won that case. I won that case.
Ma'am, stop interrupting.
Sorry, Your Honor.
But you're not sorry because you keep doing it.
Sorry.
Stop.
I was going to address the issue of money. I happen to have been the attorney that evicted her from the last location
Where was that?
in Dearborn. It happened to have been, she went from Dearborn to here. She,
Stop right now. I will get to you, ma'am. Stop the antics.
we allowed the case to be dismissed because she apparently left and left us with about $11,000 bill.
No.
We haven't chased her, we haven't done anything to it, because frankly, my client didn't want anything to do with it, but the point of my telling you this is that indeed, the allegation of having money had been raised over and over again before.
Yeah.
And as you know, Judge, if she leaves, right, he's obligated after a certain period of time to return the money, otherwise she can sue for double and treble damages. So what she's alleging simply doesn't make any sense. And as you can see through the text messaging, in fact, offer to say, leave and we'll terminate the lease. And in that, when the lease is terminated, an inspection is done. And at that point, whatever the balance is, we'll go back. Now, keep in mind that you didn't order anything to be deposited into the account until the last hearing, which was at the end of January, correct? And so that money was readily available for her to have left in December. So that,
I'm not following that, counsel, because I ordered an escrow order.
you did, and she came up with the money.
And she's been paying in the escrow order.
That's right, but you can see in the prior text messages you read, it showed that in fact, they offered to terminate the lease in December. And they told her, if you don't want this, they go. Had they terminated the lease in December, they would have gone through the process of giving her whatever the security deposit is under the law, right? And in fact, her allegation now that she has no money didn't make any sense because as soon as you ordered the escrow to be put in, to be set up, it was set up and all of a sudden the money's there. So I'm just pointing out the inconsistency in her statement.
Well, I don't find that's really an inconsistency in the statement. Your client or Miss Collins found a way, I don't know, and in any event, the money was deposited per the court order.
Correct.
Because otherwise she would have been in violation of the court order. What is the security deposit amount?
$2,000.
May I make a point?
Not yet. On May 25th, you also made a payment, it says rent first month, June, $1,500. So what is it you're disputing about the first month?
He had me pay to move in for June 1st, yet I wasn't allowed to move in until June 16th. Because supposedly they're gonna redo the kitchen. And I have, if you look at my phone, I have plenty of text messages where then finally in October, while in the hospital, they say, we really weren't gonna redo your kitchen. They baited and switched me to move in there.
While in the hospital?
Yes, I ended up.
They came to the hospital?
I ended up in the hospital for a month and a half because the basement was full of black mold, which they knew from the 2 pages from 2019 that that place cannot be lived in.
What do you say, she can have that back, please, thank you. What are you saying from 2019?
The city of Wyandotte said that that basement has a big crack in it and that it's contaminated with mold and it had to be fixed. They still, knowing I have stage 4 cancer, allowed me to move in there. And also with lupus. Within 2.5 months of moving in there, I got put into U of M hospital and I was in there for 2 months. They knew I was in there. I now have a rare disease that doesn't hold vitamins in my body and have lost over 20 pounds since I've lived in that house. And they know this. And now that I've got the copy of in 2019, the 2 pages, which also is most of the stuff I've complained about that needed to be fixed since I've lived in that house. My doctors in U of M are testing my body compared to the samples we took from the basement to see if that's what's causing my body to do a complete shutdown. Because I ended up losing my sight, which I have messages to them because they were asking me to leave in October.
Hold on. So.
While in the hospital, they asked me to move out.
Sight?
I lost my sight for 2 weeks while in the hospital.
Okay.
Because of the place I live in.
All right. So I think it's evident that Ms. Collins is going to be moving out. So, counsel, at this point, where do we go with whether or not your client's going to agree to return her security deposit, and then she's going to move out. And then we can indicate that'd be by February 28th. So that's.
I might need longer because I gotta find a place. I have stage 4 cancer, which I just had surgery.
Ma'am, you said that you found a lot of places, but you don't have the money. So
Right.
if you're getting your security
Yes.
deposit back, you have the money to pay for a security deposit, correct?
Right. My next question would be,
Is that correct?
yes, if I get it back before that, yes. The 28th, yes.
Okay.
Your Honor, we don't have a problem with giving the security deposit back. We would love for her to leave. The only issue is we want to ensure that the damages, if any, okay, we would be allowed, if we were incurred the cost, to take it out of the security deposit, like we're allowed under the lease and we're allowed under the law. But the compromise here, we're willing to give $1,000 to her of that security deposit immediately to encourage her to leave. That's not a problem. And we would hold back $1,000. And then once she leaves and there's nothing wrong, if she gives us a forwarding address like was required by the law, we'd be more than happy to give it to her.
Okay, I think that's a reasonable resolution, ma'am.
Your Honor, they do not have a legal lease. Here in 2021, they signed an affidavit with the city of Wyandotte that they legally will not rent the property or he will be served 90 days in jail.
You know,
Let me take a look at that, please. Yes, can you show counsel, please, Mr. Timmy?
He signed that with the city of Wyandotte. I'm not living with a legal.
Ma'am, please stop, just one moment. Okay, this is an affidavit of non-rental unit. It's top property address at 2223, okay, and you're 2221. So, counsel, after this, was there something that was put forth that your client does have a valid CFO for it to be a rental property?
what happened, Your Honor, is that when my client signed that, my client was actually living in that home while renovating the 2221. So when he signed it, that in fact is true. And then my client moved when he completed the renovation and began, am I wrong on this? We began the renovation in 2223 as well?
Correct.
And that's how this affidavit came into being.
Okay. So is there a subsequent affidavit from 2022?
No.
When did you start renting it out again?
She's the first tenant.
Okay, ma'am, you're saying, So I'm guessing that means no. So who was the tenant before you?
I got mail from, and there's a text message I can show you where mail was delivered in my mailbox from the tenant before me, and they said, oh, just put that in our mailbox because we'll forward it to them.
Who was the tenant before you?
I don't know the name, but I had gotten the mail because they told me, oh, the tenant had 2 children, she was a stay-at-home
Yeah,
mom.
but that doesn't tell me, that doesn't
I don't
say,
know the name of the
Ma'am.
tenant.
that doesn't say what year they lived
Oh,
there.
they lived there right before me is what I was told when I moved in.
Who told you that?
Mr. Branson and his wife.
That's a false statement, Your Honor. Mr. Ransom, why don't you tell the truth? You can hear it directly from him.
But he also made.
Hold on, no, hold on.
We lived in the 2223. My parents previously owned the home. We lived in 2223. My sister lived in 2221. We then started renovations, which also, as you see from the DiSanto issue, we had gone in front of the city to make all kinds of things in front of the zoning board to lengthen the driveway and do other things. That's all the renovations were done. Because we still lived in 22-23 and 22-21, basically, they just took it off the rolls because we were inhabiting both sides, if you will. No rent was being collected, nothing was happening. We get mail from people still. I just got a voter registration card from a Miss Becky Handler who lived there in 84. Yes, ma'am.
After you renovated the 2221
Yes,
and you moved out of the 2223,
correct.
then you were renovating 2223.
We were doing the updates and things like that.
Okay.
Yes, we did a
So
back.
after you were finished with that, what year was that?
That was probably around November of last year. And then the house.
23?
Yes.
Okay, so did you rent that out to anybody prior to Ms. Collins
No,
after you finished with the upgrades?
no.
Have you been inside of 2223 since Ms. Collins moved in?
Oh, no. Well, without her knowledge, no.
When is the last time that you were in the unit with her knowledge?
When she was in the hospital, she sent us a text that someone was moving through her house. I have that in text message.
Somebody was moving through her house?
Yeah, she said someone was on the camera, so I said, would you like me to go check? She was in the hospital. So I went into the house, said, nothing's been arranged, nothing's been moved, everything looks fine, and that was the actual last time.
Okay, so when you were there, sir, did you notice if there was any damage to the property or anything of that nature that would be of significant expense after she moves out?
No, because I didn't really look. I was looking for a person, I wasn't.
Okay, but nothing jumped out?
Yeah, nothing jumped out.
Okay.
If I may, Judge, may I supplement what he said? He called me yesterday, Mr. Branson called me yesterday and said that the front door apparently was broken because the door, what's it called?
Door closer.
The door closer wasn't working, so he did yesterday go in and repair the front door and repair the door closer so the door locked, because he was flipping in the wind.
Okay,
He actually was in my house December 1st. I have it on videotape. You have the phone in your hand?
no, we had to give the phone back to you.
Okay. I actually had the whole video of him and his wife in my house on December 1st. So, I mean, you'd like to see
Were
that,
you
so.
home on December 1st?
Yeah, he was shouting at me and told me I should feel unsafe and he'll come in whenever he wants, when I'm not there or when I'm there. I had it on tape, December 1st, so he just lied under oath on that. But you can see the videotape if
With
you
all due
like.
respect, Your Honor, the only person that's lied under oath is.
Would you like to see the tape? Would you like to see the tape that he just did lie under oath to, that he was in my house on December
Well,
1st?
I think that I had asked, was there a time that, or when was the last time you were in there with her present? The reason I asked that is because I wanted to see if there was any way that your client was able to ascertain if there were any significant damages that would cost, obviously, a significant amount of money upon Ms. Collins relocating. That's why I was asking that question, Dan. So that was the sole purpose of this court asking that question.
My client is so tired of this, Your Honor, that's the reason we made the offer of giving her half, just being blind about it. We just want her out.
So, ma'am, that seems as though that's a reasonable resolution.
No, Your Honor, I'm asking for all my money back because of this is an invalid lease, because also I have the
Okay,
reason.
show me the law that says that it's an invalid lease.
I already submitted that with one of my things saying in the city of Wyandotte, you cannot have a rental property and collect any money. And that's included in my amended motion, where I gave that to you. But here he has with the city of Wyandotte, the reason why he does not want to get an updated one is he has 2 pages of violations that he occurred with the city on my property.
Have you rectified all of the issues that were listed? I don't even see all that, ma'am.
2 pages.
I don't know what the 2 pages of, I
They
haven't
gave
had
him
a
a copy on
inspection to be
January
able to-
7th, a recopy. They
You want
mailed
to
him a
find
new.
Hold on. First of all, when one is talking, ma'am, you can't interrupt. Okay, and counsel, you can't interrupt when 2 people are talking. What is it, let me see what that is, please, that you're looking at.
Your Honor, first of all, I
He knows.
object to the document because it's clearly hearsay.
I'm just looking to see what it is. Sir, did you receive a letter from the city of Wyandotte regarding a communication from the Department of Engineering and Building?
Yes,
Okay, so seems to be the 2 pages that she's referencing. She's referencing, okay, so I'm going to presume then, is that when did you contact the engineering department to schedule the January date?
I've been in contact since December.
Put your hand down.
With Kelly from engineering, and I knew what it was is once we were out of there and I rented, it was like, I had made a phone call over there and said, do I need a certificate of occupancy? They said, there was a miscommunication, and she goes, no, you're 2223 and the 2221, and they got them crossed over. She goes, no, you don't need a CFO. Well, later I learned, oh, you do. So I immediately started contacting. So
Okay, so my question is, there's a whole bunch of stuff for 22, 23 on here. Have you made those changes?
I don't know what inspection is, because it had previous inspections.
Right, it had been from 2019. Here's what I have to do right now. Right now I have to, for safety purposes, I have to handle this in custody right now. So what I'm going to do is I'm going to order that you all go out into the lobby. And ma'am, let me just tell you where I'm heading with this. You've indicated you want to relocate. Mr. Branson has offered to guarantee, stop telling me, has offered to guarantee at least $1,000 back on your security deposit. And the balance of that upon your relocation is presuming that there isn't any significant damage, okay? So that is what is being offered at this point.
I want my 5,000 that's in with the court.
And I want the winning lottery numbers, but I don't have that either.
He doesn't have a legal right to that.
Ma'am, just one moment. So I want you to go out in the lobby, you can leave your stuff right there, and I want you to process that and think about it, because right now I don't know that I'm refunding you $5,000, because I don't know that I have all the information. So I want you to process that while I handle this in custody. And there will not be any argument out there in the lobby.
Do you want us to leave this while you're on?
Whatever you choose to do, I have to do this in custody here.
For the record, Judge, I believe she's been recording this hearing. I just heard the recorder go off.
We're not on the record, but now we're going back on the record. Hold on, just one moment.
I just overheard.
Both of you, please approach. We are back on the record in the matter of Branson versus Collins.
I just overheard the recording being turned off by her client.
Ma'am, have you been recording these proceedings?
I didn't know I was not allowed to. I have stage 4 cancer and do not remember everything. I need to do stuff so I remember and document everything.
There's a.
I didn't know I'm not allowed to.
For the record, she has at least 3 phones on her.
No, I do not have 3 phones, for the record.
2 phones, my apologies, 2 phones.
Ma'am, you are not to record court proceedings. There are transcripts that you can order if you have a question.
Your Honor, I didn't know this. I record everything, like my doctor's visits, everything, because in my mind, I have cancer brain. I don't remember everything.
Stop right now. You're gonna leave both of your phones in here, turn them both off, completely off.
I did not know this. I record everything because I have cancer.
Then ma'am, you should have brought to the court's attention that you wanted to record.
I did not know.
Stop.
I would
You
like
should
you
have
to
brought
recuse yourself,
you
by
should
the
have
way you're
brought it-
acting to me.
Stop
I would like
interrupting.
you to recuse yourself. I'm putting that on the record.
Stop
I'm asking
interrupting
you to
the
recuse
court.
yourself.
I'm asking you,
I have
I'm
a problem
telling,
with him knowing him.
I'm
would like
telling
to
you
recuse.
to stop interrupting the court.
I'm asking this to be brought into another judge
On what basis, ma'am?
because he knows him. I have a problem with it.
Nope, you already said you didn't have a
I
problem
did
with that.
not.
You sure did. You said you had no
I'm
problem.
appealing this, by the way. You are acting right now.
Ma'am, the court is not acting anyway,
Yes.
other than in
I'm a stage 4
reaction to you.
cancer patient and you're
Excuse
taking
me.
my humane rights away.
Excuse me, the only thing this court is doing is acting in complete
I would like
shock.
to know
That
from the
you're-
court that you're raising your voice at me.
Stop interrupting the court. The incredulous behavior that you've exhibited by recording these.
Do not dare say that to
Again,
me.
you are interrupting me once again. You have been interrupting throughout these entire proceedings, whether it's been verbal, nonverbal, or with raising your hand and making gestures. Now, the fact that you have been recording these proceedings improperly is extremely problematic, ma'am. Extremely problematic. Are those phones completely off?
Yes, they are.
Please show them to my court officer.
He could keep them if you'd like to, until the court is over.
They're off. Okay, very good.
I didn't hear you, man.
Are you currently on probation or parole anywhere?
No.
Have you ever failed to appear in court for any reason, sir?
Your Honor, she just gave me the finger. I'm looking at the screen.
Hold on, right now. Don't interrupt my record. Do not interrupt the record right now. Both of you, please stop. Stop. You're interrupting my record. Stop.
Forgive me, Judge. I've never, that's never happened in court.
Please stop.
Didn't do anything.
Stop, both of you.
Oh, God.
Didn't do anything.
Okay, you know what, both of you, out into the lobby, please, right now. Both of you in the lobby because you're destroying the record here.
I don't
want to be
have
here.
any opposed to you.
Have a nice day, Your Honor.
You as well.
Thanks.
I'm gonna take a brief recess for a moment.
Okay.
Okay?
Your Honor, I apologize for.
Hold on, please, hold on.
Shall be you.
Please stop talking. So we are back on the record in the matter of William Branson and Heather Collins, 240-2269. So, two things. One, I'm going to address the recording in just one moment. However, counsel alleged while I was on the record in another matter that Miss Collins flipped him off, gave him the middle finger. Now I'm going to ask you one time. Did you do that
Yes,
to Mr. Dagger?
yes.
Why?
Because I can't deal with his lies. He lies. He lies to what happened in
Yeah.
Dearborn.
Ma'am, I was on the record in another matter.
I apologize to your court. I
Please
shouldn't
stop.
have done it.
Please stop interrupting the court. I think I've run out of fingers how many times I've said that to you. I was on the record in another matter. Nothing was even being handled in your matter. You were sitting there and you just flipped off the attorney. So when I indicated previously that your behavior was incredulous today, that goes right in there to support that. Now, as it relates to the recording, except for requests for film or electronic media coverage of court proceedings, as permitted under Administrative Order Number 1989-1, the following restrictions apply to photography, audio recording, video recording, broadcasting, or live streaming in a courthouse. A, in a courtroom. In a courtroom, no one may use a portable electronic device to take photographs or for audio or video recording, broadcasting, or live streaming unless that use is specifically allowed by the judge presiding over that courtroom. The court did not give you permission for that because you did not ask. Paragraph 7, violations of this rule. If these rules are violated, the presiding judge may confiscate the device for the remainder of the day or order that the phone be turned off and put away. Violations of this rule are punishable by appropriate sanctions up to and including contempt of court as determined in the discretion of the court. The court is going to find you in contempt of court for that very, very blatant violation, and the court is going to assess sanctions. You've had an opportunity, ma'am, to process the offer that's been put forth by Mr. Branson, correct?
Am I allowed to speak, Your Honor?
Yes or no? You've had time to process that.
Yes.
Are you going to accept that offer at this time? Yes or no?
No.
Okay.
I'd like to continue to
So
live there then.
Here's what, I'm sorry?
If you're gonna make me pay my rent then I'm gonna live there till the end of my lease, because this is not a legal lease.
You don't want to live there, you've stated, and now you say that you're going to live there until the end of your lease because it's not a legal lease.
You won't let me defend myself. This is supposed to be a hearing where I'm allowed to defend myself, ask witnesses, and you're not allowing me to do any of that.
Yeah.
This has not been a trial whatsoever. This has been you controlling this entire thing. I'm not allowed to ask a witness anything. I'm not allowed to show paperwork to prove that he has other properties to know he needs certificates of occupancy.
Okay, ma'am, let me respond to a couple of those things. Number one, you're correct. I am controlling the proceedings. That is my job as the judge, to control the proceedings. Also, it is my job to make sure that the proceedings are relevant and that we are not going outside of the purview as to what the issue is, okay? So, the issue originally was unpaid rent. That rent has been paid, it's in the court escrow account. You have raised the issue of not having a valid C of O. It's been determined there's not a valid C of O. So what I'm going to do is I'm going to order two things. Number one, I'm going to order both parties to brief the court on the issue of the legality of a lease when there's not a valid C of O. That's the first thing. And those briefs are due on February 14th. That's in 1 week. Second, there is going to be an opportunity for Mr. Branson to inspect the property to see what current status it is in. And I'm going to pick the time right now before you leave. And that's what's going to happen. Yes.
May I ask that he not videotape all of my possessions while he was in there? Because that's what he wants to do.
Ma'am, if there is an area that needs attention, such as something that's broken,
Yes,
something that needs to be repaired,
yes,
something of that nature, he absolutely has the right to
100%.
take a photo.
yes,
Okay.
100%.
No videos, take a photo.
So let's put on the record with Ms. Collins, that would state that he's only to take pictures of something wrong, and there's presumption that nothing is wrong if he doesn't take any pictures of it. We put that on the record?
Okay?
Thank
Would
you.
you agree with that, ma'am?
Agree, but am I allowed to show him things that are wrong as well? And if he doesn't take a photo though, that doesn't mean it's not wrong. Because I don't want to show him areas that I know that are wrong and then he just doesn't take a picture of it.
If there are areas that you know that there are in need of repair,
Yeah,
then Mr. Branson, I would presume, would be taking a photo of it.
Yeah.
So if you're shown that area, sir, even if you disagree that it doesn't need repair, take a photo, and then when you come back, we'll address it.
and may I have somebody with me?
I already said, you can have somebody with you, and Mr. Branson can have somebody with you that's not his wife.
That's correct.
So then there's not a question as to whether or not, anyone's ganging up on anybody. So, Monday, February 10th, 5 p.m. Does that work for both of you?
Yes.
Yes, Your Honor.
Okay. I'm also going to state as well, I am expecting the most civilized behavior that there can be. So ma'am, that means no mumbling under the breath comments, nothing. You are not to be recording at all.
What about my cameras that are already in my house?
That's a different story. They're already on, right?
He knows my cameras are there.
Again, ma'am, I just said,
I'm sorry.
you have a problem with not making comments. You're not to record on your phone, not to put your phone in his face, vice versa. And then I will have you both back on the 21st.
Your Honor, I have a question. May I take pictures too of what he takes pictures of?
Sure. In the meantime, Counsel and Ms. Collins brief the issue of no C of O and what the effect is on a lease and collecting rent by next Friday, the 14th. Also, ma'am, please make a list of everywhere that you're applying for housing and see what all that detail is as well. You're just gonna keep a list and then you'll bring it on that day.
On the 14th, on the 18th.
Yes, you're raising the issue that he is illegally collecting rent because he doesn't have a C of O at the property. So I'm having both you and Mr. Dagger brief the issue as to how that applies to this case and what the ramifications are if somebody's collecting rent without a C of O. But for right now, I'm not hearing any more testimony, any more arguments. That is what the court ordered, and you're all to return on the 18th at 8:30 p.m.
Will I be able to bring my witnesses up at that time too?
Yeah, let me just say this, okay? Neither side has presented witnesses today because this court has not found that it was necessary to hear the testimony from the witnesses at this point. Because I've heard testimony from both you and Mr. Branson as to what the issues are, okay?
There's more issues.
Just one moment. And so for those reasons, the court didn't find that it was necessary today to hear from those witnesses. Perhaps on the 18th, I may need to hear from those witnesses. I'm not sure. What is the other issue?
That was the issue, that I paid for a full month and I didn't get to live there for a full month.
Your Honor, may I ask a question? Ms. Collins just stated that she didn't move in until the middle of June. Is that what is being represented to the court?
She testified June 16th is when she moved in. Is that what you testified to, ma'am? June 16th?
I brought 2 boxes in before the 16th.
That wasn't my question.
Yes.
Did you testify that you were not allowed to move in until June 16th?
I wasn't allowed to bring any of my big stuff. He allowed me to bring 2
Ma'am,
boxes in before the
Please,
16th.
you're not listening to my
That's
question.
what I'm saying, I was allowed to bring 2 boxes in.
No, listen. My question requires a yes or no answer. Was your testimony earlier that you were not allowed to move in until June 16th? Was that your testimony?
There's more to it. The
Yes
kitchen
or
was
no?
not available to live.
Ma'am, yes or no? Was that your testimony?
Yes.
Okay, there we go. So that answers your question. Right, counsel?
Yes, ma'am.
Then you said that there's other issues. What are the other issues that you're alleging?
The other issues is about Mr. Branson coming in whenever he wants.
Okay, I'm not sure how that's relevant to these proceedings right this moment.
Mr. Branson comes in at all hours of the night. Mr. Branson comes in and takes stuff out of my house whenever he wants. Just if they're missing stuff.
Okay, and that's what this witness is going to be testifying to?
Yes.
Okay. Any other issues that you're alleging, ma'am?
I have 3 police reports going on right now against him because he's been stealing my mail. And my mail's been on hold with the Postal Service, and I have a case against him
Okay, ma'am.
about that.
Okay, any other issues?
The sexual harassment case that's been going on as well.
Okay, I don't know anything about that. If there's a pen on the mail and the harassment issues, that those are criminal, if that's criminal investigations right now, then that will be left for that.
I would like to ask the court to have him stay out of my property except on the date that you have set for the rest of the time being, unless he's coming for repairs that I know of.
So, that's the finality of the issues that we have to address, correct? Okay, is that correct?
Thank you.
Is that correct, yes or no? I need verbal, ma'am, for the recording, the legal recording that the court is doing.
Thank you, Your Honor, yes.
Okay, now, counsel.
Your Honor, as we left the court, she immediately proceeded to the witness to inform of what was happening in the court in violation of the strict order of the court.
Okay, just before we get to the next issue, ma'am, did you go out and start talking to the witness about what happened in court? Yes, yes or no?
Yes. So I won't use him.
Correct. He's
Plain and
not,
simple.
he's not.
Won't use him.
Nope, what's his name?
Brian Loves.
You seem to have a hard time understanding that what the court states is something that has to be followed. I was very clear and said, do not discuss anything with anybody in the lobby. I was very clear on that.
I thought we were done.
No, ma'am, that doesn't matter. This is still ongoing. I said, do not discuss this with anybody in the lobby. So
I have 2 brain tumors, Your Honor, excuse me.
Ma'am, nope, stop, please. You've stated that many times that you have stage 4 cancer, okay? Now, then you just stated that you thought we were done. And now you're saying that you have 2 brain tumors, so that's why you spoke to him. Please, stop that, okay?
Your Honor, this actually asked for a jury trial and you never gave me that right to have one.
When did you request a jury trial, ma'am?
You never gave me a chance to request one. You automatically just put this in front of yourself.
Ma'am, you have to request that at the time of filing. All right, Mr. Dagger, what's the next issue?
I will be filing for the jury trial.
Your Honor, as she left, she immediately turned on, after speaking to the witness, she immediately turned on her phone.
My phones were in here the entire time. Both phones were in here.
Please, stop. interrupting.
My phones were left in here.
I said stop interrupting, that means stop all the comments.
Well, if it's in fact true that our phones were here, I honestly saw her using the phone, and I think the officer also saw her using the phone out there, and I thought that was her phone. If she's represented to the court, that's not her phone, then by all means, I accept that.
Were you using the phone out there, ma'am?
To call my work to tell them that I wouldn't be in because I was still in court.
Okay, and so what phone did you use?
Brian's, because both my phones are in here.
Okay. Ms. Collins, the court, as indicated, does hold you in contempt of court for your illegal recording of these proceedings earlier. And so the court's going to order a $250 sanction.
And I could appeal that, correct?
I'm sorry?
I could appeal that, correct?
You can appeal this court's ruling of holding you in contempt of court
Okay, for the record,
for recording these proceedings.
I'm going to-
Absolutely. You can certainly file that appeal. I believe it's 14 days.
Okay, I'll appeal it.
Your Honor, when do you expect her to pay?
I'm sorry?
When you designate a time when she'll be required to pay the amount?
Well, first of all, she's indicated she's going to be appealing that. So if she does in fact appeal, then it will be after that. And so otherwise, the court would give her 30 days to do that,
Thank you, Your Honor.
to make that payment.
And would I get something in the mail about this?
Get something in the mail about what?
This,
The finding of contempt?
yes. Would I get something about this so I could appeal it? Some piece of legal paper about this contempt?
You would like a written order? Is that what you're asking?
Yeah, that way I could show something that I have to appeal against.
Sure, no problem. I can make sure that there's a written order. You will receive that via email on Monday. As my staff,
And could the days,
as my staff is all left for the day, except for my two court
and could
officers
the,
here.
and could the days
And
start?
again, can you please not interrupt while I'm talking?
And could I have the 30 days start at that time on Monday, since they cannot write it up until Monday?
Sure.
Your Honor, may I please ask the court that the next time I come in front of you, that I get a chance to defend myself, since I do not have a lawyer.
Ma'am, I will say that I'm a bit confused as to what you mean defend yourself, because this court has given you ample opportunity to bring forth the issues that you're alleging. And in fact, this court has given you time to look through your phone to find messages that you stated were said or sent from Mr. Branson. The court has also given you ample opportunity to state what some of your concerns were. The court has reviewed the documents that you brought forth. The court has reviewed text messages that you have provided as well. And I don't know what defend yourself means when you say that, because I have you all coming back on the 18th to address the issues that have been raised by you. So I don't know what you mean when you're saying the opportunity to defend yourself.
Your Honor, because every single motion I did do it in a timely manner, because the motion to dismiss, I brought 2 days after I found out that he was his lawyer. So I had every single timely manner. I did my motion to suppress all the evidence the day after I got their evidence, which they did not give me in a timely manner, because they tried to scam me by saying I had to e-file, which if you would have read everything showed every single email, they tried to act as if I was an attorney and said that. If you would have read my motion.
Ma'am, I did read your motion.
Yeah, all their evidence should have been thrown out because they kept saying, oh, I needed to see e-file, I need to see e-file.
That's not how it works, okay? There are court rules that require certain procedures to be followed.
I followed everyone to the letter of the law.
Okay, did you file a notice of hearing? You did not file a notice of hearing, then there's.
As I said, he has you in his pocket.
Excuse me. Ma'am, as I stated, I'm not in anybody's pocket. And you stated that Mr. Branson stated that I was in his pocket, and you just stated that you said it. So let me just say this, okay?
He said it.
Stop, please, with your continued statements while I'm talking. You have had ample opportunity to address your issues with the court. In fact, you've continued to interrupt the court to raise your issues. Can you please stop with the papers because it interferes with the recording because the microphones are ultra sensitive. So, as I stated, I don't know what you mean when you say ample opportunity to defend yourself because the court has taken a lot of time to narrow down the issues as to what the issues are here. Okay, so we have those issues narrowed down and specified for the record. We have the date that you are both to submit your briefs. We have the date that you're going to both be there with individuals at the property to take photos of anything that needs repair or doesn't need repair. And then we're all going to be returning here on February 18th at 8:30 a.m.
Your Honor, there's one more thing. With regret, I'm just putting on the record what I heard her say outside about this court. May I do that?
What?
It's not very flattering.
Well, that's fine. I'm used to not being flattered.
She said that she's seen your picture as part of a swingers club.
I
While we
never
were
said
standing
that.
outside. I swear to God under oath, that's what she said.
I never once said that, Your Honor. Under oath, I swear under oath, I
Step up,
never said
officer.
that.
Step up, officer. He heard it.
First of all, counsel, you do not direct my officer to
I'm
stand
sorry,
up.
Your Honor. I'm really angry now because we know where this is.
I said, Your Honor, and I will repeat what I said. I said, I have text messages. He is in a swingers club, and that might be how you might know him, and that's might be how, listen, this might be laughable, but I will admit what I said. I have no shame in what I said because I was upset because I feel like I'm losing the case. So I'll admit what I said. I have no shame in it because I'm losing my life here right now. Because I know he's doing something illegal, all right? But just let me say what I said. If I'm gonna be accused of saying something, let me at least say how I said it, all right? That I have text messages where he admits he's part of a swingers club. He's part of the Jeep Swingers Club, part of Wyandotte, right? And I said, maybe that's how he knows the judge, and maybe that's why he has her in the back pocket. I asked and said, maybe that's how. If they heard it as a different thing, because they were all the way on the other side of the hall, then they heard it as a different thing and twisted the words. I never said you were part of. I said maybe that's how. I never claimed you were. So I will say that's how. Never claimed you were. So that's how I said it. So don't say I said you were.
I don't know what to say, Judge.
Well, I mean.
I'll admit what I said. People are allowed.
It's laughable.
I will laugh about it, but I'm allowed to have my own feelings.
You can have your own feelings, but just as though you don't want inappropriate things being said about you, don't say those about other people. Lucky I have a thick skin, quite frankly, and I've already established that I do not know Mr. Branson. Maybe I've seen him at some point during my campaigning 7 years ago, whatever it was. I don't know, but I've already said that. I've already said all of that. And so if you don't have to believe me, ma'am. You stated that in fact, you did state, I think earlier, that you were fine with everything moving forward and that you believed what I said. In any event, ma'am.
I can't believe you when you're allowing someone against the law to do things.
Ma'am, I am not allowing anybody against the law to do anything, okay? There has not been a citation given to Mr. Branson, to my knowledge anyway, that would have him in front of this court. And I just said, when the two of you are to be sending your briefs to the court, both you and Mr. Dagger, so that you can brief the issue and we can address the issue of not having a C of O. So before you start accusing this court of doing something improper, please take a few moments to process it, because I haven't allowed anybody to do anything illegally here today. And in fact, I'm having you and Mr. Dagger brief the issue of no C of O. So that's 100% opposite of what you've just stated. I'll see you all on the 18th.
Thank you.
Court's in recess.
And I apologize.
Well, that's it. That's it for today's docket. I will see you guys tomorrow on the next one. I broadcast every day at 3 o'clock p.m. Central Time, 4 o'clock Eastern Time, and I have no idea what time in California. So figure it's, 2 hours ahead. If you guys are not subscribers to this channel and you like this content, do me a favor and please subscribe to this channel and help this channel grow. I noticed that we had a new subscriber and I'd like to welcome them. So any new subscribers to this channel, I'd like to welcome you right now. So that's it for today. Ta-ta and ciao ciao. I will see you guys tomorrow.
Breakdown, you're the one I call. From the mountains high, come down to it all. With your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. Daniel, you make it better. From the wires tangled up to the broken dreams, you know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Fix it, Daniel. Fix it, Daniel. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, fixing your album, standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's okay.